Hi everyone, I'm Sam McGovern. I'm a trust attorney here in California, and I wanted to answer one of the most common questions people often ask me, which is what is the difference between a trust and a will? And which one do I need? Let's start with a will. A will, or a last will and testament, in the simplest terms, is a legal document that specifies how your property will be distributed after you die. A will names an executor, guardians for your children if you have them, and names beneficiaries or the people who will receive your assets after you pass away. An executor or personal representative is the person who will manage your estate after you pass away until the probate process is complete and assets have been distributed to the beneficiaries. Guardians, of course, are those people who are legally responsible for the care of your children until they become of legal age. If you have minor children, naming a guardian or guardians for them in a will is critical. In the terrible scenario where you could potentially pass away prior to your children becoming adults, you wouldn't want to put a guardianship decision in the hands of a probate judge. After all, you are the best person to decide who should care for your children if you are no longer able to do so. The key thing to remember about a will is that it really only becomes effective in most cases when it's filed with the probate court and a judge approves action based on your will. That brings us to trusts, which most commonly you might hear referred to as living trusts or family trusts or revocable trusts sometimes. But a trust is a legal agreement that allows you, the grantor, the person putting assets into the trust, to appoint a trustee to manage those assets on behalf of the beneficiaries. In the vast majority of trust agreements, you will continue to be the trustee and beneficiary during your lifetime, and your designated successors will step in and replace you as trustees and beneficiaries after you pass away. A trust is sort of like a wallet, in that its purpose is to hold all sorts of different assets. Once we create a trust, we often will retitle your property, like your house, to the trust. Sometimes we'll also either title financial accounts to the trust or name the trust as a payable on death beneficiary of your various accounts. One key difference between a will and a trust is that a living trust keeps significant assets out of probate court where a will does not. This makes it much easier and quicker to manage your affairs under a trust. It also keeps information about your estate private, unlike a public probate court record. Trustees of a trust can also manage assets for an extended period of time after you pass away. Potentially when we have a beneficiary who is a minor or is legally incapacitated, or any other scenario where we would not want a beneficiary to receive your property with no restrictions whatsoever on its use. With a will, on the other hand, executors of a will manage assets only until the probate case has concluded. One final difference between a will and a trust is that a trust can be used to establish care for you if you become incapacitated at any point prior to passing away, whereas a will is only effective after you die. A trust includes provisions for your trustee to step in and manage your assets for your benefit and care for you if you're unable to do so for any reason. If you have any additional questions about wills, trusts, and estate planning here in California, please feel free to reach out to my office, the McGovern Law Group. Thanks so much for watching.